Assalamualaikum and hi to Dr. Azrin. My name is Muhammad Aziz Shamsu Amri as the first presenter. So our case study title is between Mr. Nik Ishamuddin bin Nik Mansur and Petroleum Nasional Berhad. The award number is 1366 of 2024. To begin with, I will discuss about the organisation and the nature of the conflict. First, this case involved Petronas, Malaysia's national oil and gas company. The claimant, Mr. Nik Ishamuddin bin Nik Mansur, served as a senior legal counsel for approximately 28 years before being seconded to Petronas Karigali Iraq Holding BV in Dubai. The conflict began when several female employees lodged complaints alleging workplace harassment, bullying and sexual harassment during his job overseas. In response, Petronas initiated an internal investigation, issued a show cause letter, conducted a domestic inquiry, and eventually dismissed the claimant for serious misconduct on 20 December 2018. However, the claimant challenged the dismissal under Section 20 in bracket 3 of the Industrial Relations Act 1967. He argued that the domestic inquiry was procedurally unfair, violated the principles of natural justice, and that the dismissal decision had already been predetermined. In contrast, Petronas maintained that it had followed its disciplinary procedures and dismissed the claimant only after he was found guilty of serious misconduct in accordance with its Code of Conduct and Business Ethics or COBE. So now, moving on to the parties involved, this case consists of both primary and secondary parties. The primary parties are the claimant, Mr. Nik Ishamuddin bin Nik Mansur, and the respondent Petronas. The claimant had served the company for approximately 28 years as a senior legal counsel. He argued that his dismissal was unfair and lacked just cause or excuse. On the other hand, Petronas maintained that the dismissal was justified because it followed the company's disciplinary procedures, including the domestic inquiry and the Code of Conduct and Business Ethics or COBE. And then, the secondary parties include the 4 female complainants, the Human Resources Department, the Domestic Inquiry Panel, and the management team responsible for handling the investigation. Each party had different interests. The complainants wanted a safe and harassment-free workplace. Petronas aimed to protect employee welfare and its corporate reputation, while the claimant sought to protect his employment, professional reputation, and his right to a fair disciplinary process.
Now, let's move on to critical analysis. Conflict management strategies employed. When handling severe workplace misconduct, our Human Resource Department did not treat the situation as a minor interpersonal dispute. Instead, we executed a highly structured organizational level strategy to manage the crisis. Our very first step was executing formal separation and structural containment. We implemented structural decoupling by immediately demobilizing and relocating the claimant from his foreign settlement in Dubai back to corporate headquarters in Kuala Lumpur. This rapid physical move was absolutely vital to shield our vulnerable workers, diffuse immediate workplace tension, and also establish a safe environment before the deeper investigation even began. Once containment was secured, we transitioned into a formal, highly structured administrative investigative process. We initiated a notification system by issuing an official showcase letter which detailed 13 specific structural grievances and gave the employee a clear opportunity to respond in writing. When his written explanations were reviewed and found completely unsatisfactory by management, We move to an internal jurisdiction to plan by governing an official domestic inquiry panel. This panel functions as a formal, rule-governed, quasi-judicial internal tribunal. It allowed both opposite sides to systematically present verbal testimonies and documented evidence to completely neutral internal arbiters. Throughout this entire process, we maintain rigid policy enforcement by matching each specific grievance directly against explicit clauses in our corporate code of conduct and business ethic. We kept the dispute grounded in an objective framework rather than letting it devolve into a subjective back and forth argument. Finally, the strategy concluded with a formal termination of service, but we purposely incorporated an internal administrative appeal procedure. This multi-tiered corporate review path provided layered accountability, ensuring the employee's counter-argument were thoroughly examined and officially dismissed by corporate HR before the termination was finalized. Now, let's move on to the effectiveness of the strategies. The strategic conflict management choices applied by the company proved to be highly effective from both corporate governance and also legal defense perspective. First and foremost, the sudden demobilization from Dubai to Kuala Lumpur was an incredibly effective protective intervention. It immediately put an end to the toxic behavioral pattern on site and completely wiped out the severe power imbalance that was causing deep distress to our junior female employees. By safeguarding the daily operational environment, this quick containment directly restored a healthy psychological safety climate and lowered systematic anxiety across the team. Second, anchoring our entire process within the code of conduct provide a powerful objective assessment framework. It successfully shifted the corporate focus away from personal animosity or subjective verbal disputes into a hard and fast evaluation of clear-cut policy compliance. This neutralized any defense claims of personal bias or selective policy enforcement. Third, the domestic inquiry mechanism showed its true long-term value during the subsequent industrial court trial. Because our internal inquiry panel meticulously documented every piece of oral evidence and preserved verbatim cross-examination records, we built an extensive chronological case archive. To this proactive record keeping acted as a crucial defensive safeguard when the passage of time created judicial barriers, specifically when a primary complainant could no longer be legally compelled to appear or testify in person because of international boundaries. The industrial court accepted her prior cross-examined statements directly from our archived domestic inquiry files. Ultimately, this through corporate archiving served as an ironclad legal shield that successfully protected the organizational interests and completely withstood intense judicial review. Moving to conflict solution as an HR approach. From a strategic human resource management standpoint, resolving severe misconduct demands an absolute, uncompromising commitment to employee well-being, legal compliance, and corporate ethics. When faced with a persistent toxic passion that deplete employee mental energy and drive up turnover intentions, HR decision makers cannot rely on weak compromises or soft accommodations. We must prioritize definitive dismissal over minor disciplinary concessions. Gross misconduct completely shatters the fundamental contract of service, making total removal the only justified response to restore organizational health and prove that employee safety is a core corporate strategy. However, to ensure that an extreme disciplinary action like immediate determination is legally sustainable, HR practitioners must follow strict procedural equity and natural justice. This means granting the accused individual full access to corporate policy documents, a transparent breakdown of explicit charges, and a fair multi-day domestic hearing to mount a comprehensive defense. To strictly comply with natural justice principle and eliminate any claims of administrative bias, we maintain a rigid segregation of roles. The internal presenting and prosecuting officers were kept completely separate from neutral inquiry panel evaluating the evidence. If HR tries to act as both prosecutor and judge, the structural equity of the hearing collapses, leaving the firm wide open to wrongful dismissal liabilities. And finally, a true HR solution must look forward to prevent recurrence. Beyond the dismissal itself, HR must implement continuous, proactive behavioral training and cultural orientation sessions. The sessions must explicitly outline our strict workplace rules regarding gender dynamics, professional boundaries, and respectful communication. Supporting our unbiased inquiry lines with this ongoing preventive training solidifies long-term regulatory compliance and permanently strengthens anti-bullying governance across the entire enterprise.
Although the industrial code upheld Petronas' decision, there are still several improvements that could strengthen its conflict management practice. First, Petronas should establish an independent investigation team that operates separately from the Human Resource Department. This would minimize perception of bias and improve procedural fairness during disciplinary investigation, since the claimant questioned the impartiality of the domestic inquiry process. Second, the company should provide regular anti-harassment, workplace respect, and cultural awareness training, particularly for manager and employee working in multicultural environment. Such training help employees recognize inappropriate behaviors, encourage respectful communication, and create a physically safe workplace. Finally, HR managers should strengthen their ethical responsibility by balancing the organization interests with employees' rights. HR must conduct impartial investigation, maintain confidentiality, provide equal opportunity for all parties to present their case, and uphold the principle of natural justice. By doing so, HR can build employee trust while ensuring that disciplinary decisions remain both ethical and legally defensible.
To conclude, the industrial court found that Petronas had just cause to dismiss the claimant because it followed a fair disciplinary process. This case highlights that ethics, fairness, and proactive HR practices are essential in creating a safe workplace and maintain positive employee relations.